There's a battle brewing between the Modi government and the judiciary, and the question now is who will blink first? I'm Barkha Dutt, you're with the Mojo Story. Our focus today is on the debate surrounding the appointment of judges. The law minister has more than once, in fact, now multiple times, questioned the efficacy of the collegium system, where a group of senior judges take all decisions pertaining to the appointment and transfers of other judges. In the meantime, we've seen lawyers across three different states and high courts protest over the first decision by the collegium, which involves the transfer of judges. In the meantime, 19 names have been returned by the center to the collegium. In other words, only two recommendations that were made for the post of judge have been appointed by the government. But actually, by law, it's the collegium that has the last word, especially after a reiteration. But the Modi government is questioning the entire system of the collegium, saying this doesn't exist anywhere else in the world. And there are several retired jurists, including Justice Lokur and Justice Deepak Gupta, who say that the collegium is not asserting itself strongly enough against possible government interference. The Supreme Court, of course, recently chose to shadowbox in another way. It drew new red lines during the hearing over who should appoint election commissioners, seeming to suggest to the government that if you interfere with how we appoint judges, we will interfere in how you appoint election commissioners. The fundamental question still remains: who should appoint judges? Are judges accountable? Are judges answerable? And if they're answerable only to themselves, how do we stop the closing of ranks? And is the answer to a collegium system with all its flaws government appointments? Most would say no to that question. Let's introduce our guests on the program today. Joining us on the program, first up is Raviteja. He's an advocate with the Andhra Pradesh High Court. He was one of the lawyers protesting in Andhra Pradesh over the transfer of judges. Also joining us is Vikram Hegde. He's an advocate and an analyst practicing in the Supreme Court. Also joining us today is Asim Pandya. He's a senior advocate. He, of course, remember practices at the Gujarat High Court, where there were also many protests over the transfer of judges. And finally, Alok Prasanna Kumar is with us. He's, of course, with the Vidhi Legal Center, its co-founder. Good to see you, Alok. And finally, PKD Nambiar, political analyst, someone seen to be a supporter of this government, is with us as well. And we just lost him there. I think let's just get the ball rolling straight away with first comments. Let's bring in Asim. Asim, let me start by asking you, unprecedented that the first decision the collegium took actually ran into rough weather. And then, protesting lawyers have met with the Chief Justice Chandrachud, but the larger debate still remains. What are your thoughts at all that is going on?
Actually, the collegium system has not worked efficiently. That is the experience of all. So everybody wants to find a solution of it. In fact, if we examine the NJSC, which was introduced by 99th Amendment, Constitutional Amendment, I do not see anything per se pernicious in the NJSC Act or the Constitutional Amendment, because it was so balanced. The entire constitution of the NJSC, in my view, it is absolutely a balanced composition, and it at least the Supreme Court should have allowed at least this NJSC to function for some time, and it should have come out with the review if at all it was not working properly. So my view, commencing with this, that everybody is unhappy with the current system and everybody needs a proper alternative for the collegium system.
Now, you're referring back to the NJAC. For the perspective of our audience, this, of course, was a legislation brought in by the Modi government, but supported unanimously in Parliament, that gave the government also a say in the appointment of judges. It was read down by the Supreme Court. Why do you believe, Asim, that the government, any government, doesn't have to be this government, it could be any government, any politician, would be fairer in the appointment or the transfer of judges than judges themselves?
If you examine the composition of the NJSC, you will realize that Chief Justice was ex officio chairman, and two other senior most judges were also member of it. And the third one was the law minister, union law minister, and the two members are to be nominated by three members. One was Prime Minister, another was Chief Justice of India, and third one was the opposition leader. So it was not that there was executive interference by amending this constitution. So in my personal view, it was a perfect balance which was struck by the persons who had recommended the amendment in the constitution itself. So in my view, I think at least, as I said, that it should have been allowed to function for some time.
Well, the good news, if it can be called good news, is that I think we all think the government may be moving towards another attempt at a legislation very similar to what you think is a perfect balance, which is basically giving the government a say, bringing in a legislation on how judges are appointed. But this move is triggering very, very strong responses from those who have served on the bench. And before I open this up for wider debate, I just want to play a little excerpt from an interview I did with Justice Madan Lokur, who, of course, retired from the Supreme Court, who has very, very strong words about the law minister and the kind of comments that have been made about the collegium. Listen in.
Well, tell me one country in the world where the government sits on the file of appointment of judges. Is there any country like that? I mean, what is it? Just taking pot shots at the collegium, taking pot shots at the Supreme Court? Tell me one place in one country in the world, democracy, I'm not talking about autocracies or, those kind of countries, where the law minister or the minister for justice takes pot shots at the Supreme Court. Tell me one. Come on, ask the law minister these questions. Why are these questions not being asked? He's the one who's asking questions, but he should be the one who's giving answers.
Yeah. Are you angry with the law minister?
Well, I'm upset generally, because I think the Supreme Court Collegium is not standing up. They should stand up and ask the law minister, what is it that you want? Okay, just come up front and tell us what you want, and tell us why are you not making appointments. So unless the collegium stands up, this kind of pot shots will just go on and on and on. Where will it lead anybody?
So one view there saying the collegium has not stood up for itself, and another view coming from Justice Deepak Gupta questioning the Chief Justice, asking why was the collegium's first decision to transfer instead of appoint judges. Listen in.
You're absolutely right. It's facing a turmoil, and unfortunately, the first decision taken by the new Chief Justice of India was to transfer judges. I wish the first decision by the collegium should have been to appoint judges. We are woefully lacking judges rather than transferring them.
So these are also some of the questions that are being raised about Justice Chandrachud's first set of decisions. I want to bring in Vikram and Alok at this point. Alok, let's start with you. So two kind of critiques there. One saying the collegium is not asserting itself. The other saying, why did they choose to do transfers, which led to people like Teja and Asim actually protesting rather than get into the business of appointing judges. Now you see the center actually just returning 19 names, even though technically it's supposed to be the collegium's prerogative. Alok.
So this is where I sort of say that the collegium system is over. It's a controversial view to have. But what Justice Madan Lokur and Justice Deepak Gupta have said without saying is that the collegium system is no longer working. It is not working as a collegium system because there was a memorandum of procedure. There's a set of rules which make the collegium system the collegium system. And if one part of the system, which is the judges themselves, are not willing to enforce these rules, then the system is done for. What we have is what I like to call the search and selection committee system, where the collegium sends some names, the government picks some names, appoints them whenever it feels like. Effectively, it is now the government selecting some names, deciding their seniority, and appointing them to the high courts, and not so much the Supreme Court, but primarily to the high courts. In fact, I wrote recently about this has happened to 21 judges of the high court, where the names, when they were sent in, they were supposed to be of a certain seniority. The union government has ensured that they're going to be appointed at a lower seniority. There were 42 judges whose names were segregated from their cohort of judges and appointed later. This is not envisaged in the collegium system. And the collegium has not stood up for itself. The moment the first such segregation happened, if you recall back in 2018 with Justice Joseph. That should have been the moment where the collegium said, no, we're not going to tolerate this. The collegium has unfortunately not done so. And I share Justice Lokur and Justice Gupta's agitation that why are you not standing up for the system? That judges who will say the collegium system is great, but you're not willing to enforce it when the government pushes back.
But is the alternative? Is these sort of the warts, as it were, on the body politic of the collegiate system? Is the alternative, as Asim Pandya argues, for going back to the NJAC, a legislation that will give the government a say in the appointment and transfer of judges, Alok?
My solution is, I think, slightly different. And I think Mr. Asim Pandya and Mr. Raviteja have actually told us why even the NJAC may not be a best system. I believe the best system will involve a balance of three stakeholders. Of course, judges should be involved. Of course, the union or the state government should be involved. I believe the third pillar of this is the bar or the civil society. I believe it shouldn't be, and with due respect, Mr. Asim Pandya shouldn't be having to lead a delegation of advocates, or Mr. Raviteja shouldn't have to go on strike. They should be in the room when the decision is taken, or at least someone representing the bar or someone representing civil society, because the judges aren't doing this for themselves, or the government isn't doing this for themselves.
So you're saying give the judges, the government, and the bar a say in the appointment and transfer of judges. That's a very interesting new model, but there are many people who do not think the government should have any say at all. Now, I want to take look at, that's not possible, but let's take a look at three judges, at least three, over whom there has been, can we take the banner off? There's Saurabh Kirpal, who believes that he's been obstructed because he's gay. He's openly gay. He has said so to me in an interview that he believes that's the reason he's not being made a judge. There's Justice Barkha Dutt. This has exercised the Supreme Court bench enormously. Why has this name not been approved? And it hasn't. The government is just sitting on that file. And there's Justice Akhil Qureshi, who actually had to retire without elevation to the Supreme Court. Now, this, some might say, is what happens when you give the government a say. The government right now technically doesn't have the last word, but simply by delaying response, it can actually ensure that a judge is chosen or not chosen. Before I go to Vikram and to Teja, PKD, you're a supporter of this government. Do you think that this is a battle they should be picking? Because remember, the Supreme Court has retaliated in a different sort of way. It is now saying, give us a say in how you appoint election commissioners. This shadow boxing is not great for the health of a democracy. The Supreme Court has begun to respond in open court as well. Those were the comments on our screen right now that came from Justice Kaul at the bench. Go ahead, Mr. Nambiar.
Barkha, the problem now is that, as you said in your initial comment, that somebody is appointing themselves as a judge or whatsoever. It is never heard of anywhere in the world. And this is an alien things to all of us. Have you ever heard anywhere in the world the judges are appointing the judges? Definitely no. The earlier speaker, he was just mentioning that there should be some kind of a role for the executive. At the end of the day, we are a democracy. And I think the judiciary should also be accountable to the people of India. So I'm not saying that they need to be elected or selected, or that's a separate story altogether. But today, the behavior of the judicial system in our country is if that they are above the constitution. In fact, there is nowhere it is written in the constitution. And in fact, this collegiate system itself has come up on the basis of some kind of an interpretation of some kind of an order. So in a way, and it is also becoming more of like a family affair. We always talk about, in your multiple times over the so many years, I have heard you talking about nepotism, whether it is in Bollywood, whether it is in the politics, and so on and so forth. But today you look at, and I don't know whether if I say this, will it become a contempt of court tomorrow? I don't know. But then the truth is this, that it's becoming more of like a family affair. You find the judges in the same house, there are 2 or 3 judges are coming up.
But there are 19 names. May I interrupt your flow just to point out that 19 names have been returned by the center. Mr. Kirpal's elevation to a judge has been obstructed since 2017 because of his sexuality. We cannot give governments this kind of overarching power either. I'd actually prefer a system where their powers were defined, because this kind of open-ended power means that they can just delay, and delaying itself is a decision.
I am definitely for the opinion there should be slightly more clarity. Neither the judges should appoint judges nor the just government, because then of course there will be questions about the neutrality of these judges. But I feel that we have to devise a new method wherein both the executive I mean, or the government has got its own say. Right now, what they are doing is delaying it. So one thing I'll tell you, when the collegium sends a report of a judge to for an elevation, what the government is doing, it is not just holding on in the only because of some particular political reason. They are also supposed to look at their intelligence agencies are supposed to check the credibility of that particular individual. The individual become a judge or even go to a higher position. So the government also has got its own responsibility as far as clearing an appointment. It is not just because of some reason they are holding it. I'm not saying all the positions may have been held by the government with a pure intention or wrong intention. I'm not going to comment on that, but then there is no doubt there has to be slightly more clean and clarified and open ending. This looks like more of like a more than collegium. I would say it's like a group of people are sitting and choosing their own
Okay.
the colleagues, and which is not acceptable.
Let me bring in Vikram at this point. Vikram, if we were to look at a recent controversy, an injunction forbids me from saying much, but it involves a judicial officer in a so-called sex tape. Now, I believe people's personal lives are their own. I believe they have a right to privacy, but there are questions of consent here. There are questions over, whether this was between two consenting adults, or given the fact that it involves a hierarchical relationship between the officer and his stenographer, whether we should actually be looking at this as through the prism of Me Too. We don't know. We don't know because we can't report it, because immediately there was protection for this judicial officer. Some might cite this as an example of how there's a banding together of brother judges and there's no accountability. But is the alternative the government? Why would we trust politicians to be more transparent, more fair, more neutral? Vikram.
See, there's one question about, is the alternative the government and will the politicians be more neutral? The other way to look at it is, okay, there is power over the judges today, and there is when there is some sort of disciplinary action to be taken against a judge, will the politicians be neutral is one question. The other thing is, do you want to give this power to the politicians at all? Should a judge be under the impression that the government in power will be the ultimate disciplinary authority over me, irrespective of whether the politicians are going to be neutral or not, or the executive is going to be neutral or not? I think it's just a question of the structure shouldn't be in a manner where it's up to them at all. That I think is at the basis, at the root of the independence of the judiciary. Of course, we are talking about not someone of the higher judiciary who's appointed by the collegium. Irrespective of that, I think the structure should remain separate. The disciplinary process especially should remain separate.
Yeah. So, Vikram, before I take this to Teja, I mean, what is the one change you'd want to see in the collegium system?
The legitimate complaints about the collegium system, about it not having promoted diversity within the judiciary and or having made the system transparent enough, are all valid. Even when it comes to the NJAC, I would say that there is one angle which hasn't been spoken of enough. The Supreme Court and the Union Judiciary, as the Constitution sees it, is a court that oversees a federal system. Even the NJAC, as was contemplated, only included executive from the union level. If we look at some other large federations, like the US, the judges' appointment system over there is placed before the Senate, which necessarily includes state representatives. I think the voices of the states are not being taken into account, even if we go into the NJAC system.
That's a very interesting point, and I want to go to Mr. Raviteja now, because remember, three states, bars associations of three states actually were protesting, and these were the judges at the heart of those controversies. It in fact became the first challenge, as it were, for the Chief Justice, and many have criticized him in his own peers. Why was this the first collegium decision on transfers? What was the need? But I must ask you, Teja, the government could have also done this. An NJAC model where the government had a say, that committee could have also come together to actually transfer a person of impeccable integrity. We could be looking at exactly the same situation, and all of you protesting, you and Asim and others in your states, even if there was a different system of appointing and transferring judges. Teja.
In my personal opinion, and most of the opinions which my colleagues will concur with me, we are not just inclined towards one system or the other. We would rather say there should be more definitive role plays for every department, or I mean for the judiciary, for the executive, in either in the present system or in the NJAs. The definitions of the play, what they have to do in such an activity or take up such an activity, is not being actually being laid down. Whatever the memorandum of procedures or whatsoever, just prescribe the overall and maybe timelines for any recommendations or for any transfers. But the definitive pathway on which an appointment or a transfer has to be dealt is not actually being done either by the Supreme Court nor even by the central government. The problem here is there is no transfer policy, nor there is any elevation policy, even neither for the Supreme Court nor for the central government. And as my other friend there says, that the right of the states has been actually scuttled to the extent of only giving the information about the office advocate who might be elevated or who might be transferred. And this information whatsoever of nature is being used sometimes to target the judges of integrity, or sometimes to target the judges whoever have elections on. Unfortunately, most of the times, collegium system is on a back burner because of the reasons. For the last many Chief Justices of India have been facing allegations on one way or the other, and those allegations, they don't want to deal with it in the system with which general litigant would be dealing with it. That's where the whole problem rises up. And they just want to keep themselves away from the scrutiny which the judicial system would do when there is such an question rising on any other.
Some of us are old enough to remember a time when there were tears over this issue, and there was Justice Thakur's time when actually, he was weeping, he was sobbing, and I just want to play that little clip before we get comments from all of you. Listen it.
It is not only in the name of the litigant, the poor litigant, people who are languishing in jails, but also in the name of development of this country, its progress, that I beseech you to rise to the occasion and realize that it is not enough to criticize. You cannot shift the entire burden to the judiciary. If you compare the performance of Indian judges with those in other countries, we are heads and shoulders above them. American Supreme Court decides 81 cases per year, the entire Supreme Court. 9 of them sit to dispose of just about 81 cases. Average disposal of an Indian judge is 2,600 cases, whether it is a Munsif or a Supreme Court judge.
Now, the reason this is so interesting is, Asim, one of the things, Asim Pandya, that the law minister said is that judges, instead of disposing of cases, are too busy politicking over appointments and transfers, and that's why this collegium system has to go. That's why I thought it was interesting to rewind to history a few years ago only. Mr. Pandya, what should happen next? What might happen next?
Actually, since NJSA has been declared void and unconstitutional, we will have to deal with the current system of collegium. Now, there are few suggestions. In fact, I was also recommended for judgeship in 2009. but somehow because of some political interference or maybe what reasons had weighed, my appointment was not made. I was the first person who challenged it legally by filing a petition. I was not interested in appointment. I was interested in reforms. And three things I found out after reading the judgment in SP Gupta's case, then the Supreme Court Advocates Association case, then presidential reference. From all reading of all three judgments, I found out that there are three areas where this system can be made effective. First is that when a name is recommended to the collegium and certain adverse material is placed against him, then presidential reference case in paragraph 21 clearly contemplates that Chief Justice may call upon the candidate concerned to explain about the adverse material which is being used against him. So,
So a
but
right
there
of
the word,
response. A right of
yes, there is,
response must be given to the judge who's not
yes,
elevated. All right.
yes.
Okay.
So their word use is may. My suggestion is that it should be shall, because a person whose name is being recommended is absolutely unaware of what is being used against him. So he at least need to have an opportunity to explain or to withdraw his candidature if at all he is interested in. Second
Right.
is that there has to be a mechanism to provide the reasons on demand. I am not suggesting the earlier method of uploading the resolutions of the collegium, uh, uh, compromising the dignity and reputation of a person, because that would disclose the reasons why he is unfit. I am not of that view. I am saying that upon demand of the candidate concerned, he should be made known what are the reasons that had weighed in non-appointment. And third is full-scale judicial review. Right now, it is truncated. It is limited. It is limited to the extent that court would be examining, judicially reviewing the eligibility, but not the suitability, and whether the
What
consultations.
happened to your case when you challenged it? What
It
happened to
was
it?
dismissed in limine court, and the person who dismissed it, he became victim of the collegium system or the current
Oh
system.
gosh.
Justice Jayant Patel, who was also transferred, and he had to resign.
So multiple
But
ironies there in your own account and the person who dismissed your case. Okay, let me take what you've said. Three very good. Sorry, were you trying to complete your point,
and
Mr. Pandya?
one more
Yeah.
suggestion,
Sure.
one more
Sure.
suggestion, that full scale review means uh, person should be allowed to agitate what reasons had weighed. Today the limited judicial review is that whether you are eligible. So eligibility is subject to judicial review, but suitability is not subject to judicial review. And consultative process, the court can examine whether the consultative process envisaged under the
Yeah.
first judgment cases or second judge, whether it has been followed or not. Now
Very
this,
interesting. Sorry, I'm going to interrupt you because time is limited. I
yes,
want to take
sure,
that
sure, okay.
your account to actually Alok. Three very interesting suggestions, in fact, by Mr. Pandya, including the right of response, more transparency. What is the basis over which you do or you do not elevate somebody? And instead of having a broad thing that a collegium must make its decisions public, the candidate should have the right to ask. Show it to me at least. But he says the NGAC is void. I'm pretty convinced that the way this head-on collision is going, obviously a new legislation is coming. Is that where our attention should in fact be? Or, you know, will the shadow boxing, you think, continue with the Supreme Court drawing red lines around how election commissioners are appointed?
I think that election commissioner issue is a little bit of a red herring, to be very honest, because
Yeah.
I think the collision has been coming for a while now. I think we have seen 5 years of very poor functioning, to the extent that, as I said, it is not even, I wouldn't even call it the collegium system anymore. I do think if there is a legislation coming, I think it's better to focus the efforts than trying to say collegium is best, restore the collegium. Because let me say this in a very blunt manner. The collegium has failed both at independence and at efficiency, in the sense that the kind of judges whom we have found through the collegium system have become this closed circle of old boys clubs. And this has become a situation where you earlier speaker mentioned about the nepotism. It's not even just about nepotism. You are only literally appointing from a small circle of high court lawyers who have had very successful practices for a long period of time. Not to say all of them are bad, but when you're not expanding that pool, when you're not taking more names into account, it will result in what Vikram pointed out, which is a lack of a representative character in the judiciary. Further, the government has constantly increased the total number of High Court judges, but the Collegium has never been able to ensure that we've had more than 720 or so judges. So, I mean, I think the sanction strength of High Court judges right now is close to about 1,200. We've never had more than 720 judges in the High Court serving at any one point of time. In fact, the number now is much lower, and it defeats the purpose. If you're not going to be able to fill up vacancies because the process is so complicated, so unstructured, so non-transparent, you're not even fulfilling that basic requirement. So I think I don't see either on the independence aspect of it or on the efficiency aspect of it that we've had a good run with the Collegium. Maybe the Collegium came when it came for particular reasons. Those may have been valid at that time, but I think it's now time for us to move on and start a fresh conversation. What could be the system of
what could be the model?
appointment
And I
of
think one of
judges
the
that will actually help? What could be the model?
And one of the points you made was both you and Vikram, representation for states. And I think certainly Mr. Pandya and Mr. Teja would agree with that. Teja, if I can get you in for your last thoughts before we give Vikram the last word. The protests across 3 states, the Madras Bar, Gujarat, Andhra, and then Justice Chandrachud assured that these would be looked at. Are you satisfied with that response?
No, in fact, I'll just explain how these transfers are. I think I should, with my little knowledge about the transfers happening, I should also bring it to your notice. When the Collegium sat, I think in the first week of last week of September, the whole Collegium couldn't sit down, and one of the judges was holding the court till the late nights.
That was the present Chief Justice. At that time, that the Chief Justice was Uday Lalit. Yes.
And the recommendations made in that Collegium meeting have been thwarted in the subsequent by a notification of the Supreme Court itself, stating that these recommendations are not being considered and they would be done fresh. But at the same time, the transfers which have been proposed in that Collegium system, and when the responses of those judges who are to be transferred has been taken up, and through that Collegium meeting, they have been taken into consideration. And especially coming to the issue of our state, Mr. D. Ramesh and Mr. Devanand, both are of good integrity, and the bar elevated from the bar, and they have the record of disposing thousands of cases of many subjects. And when such efficient judges are to be transferred in a very opaque manner, I think Collegium has to reconsider its decision. The whole problem with this system of the Collegium, I don't want to speak in comparison with the NJAC, but the problem with this system of the Collegium is that this system of Collegium doesn't want to face a question. The hypocrisy is deep dwelled into this system of Collegium, where this Collegium doesn't want to face a question nor speak about the rationality in doing any of the actions which they would have performed. That is the basic question which any advocate of howsoever junior or howsoever senior in this system are always proposing to the Collegium to face the questions, to deal it in a rational way, and evolve as a process so that it becomes transparent and it becomes more democratic in nature, including the social classes of all the sections of the Indian society.
Fair enough. Let me bring in Vikram for a last comment. Vikram, there's also another kind of narrative, and that narrative says, if there is a new legislation with the government returning, for example, these 19 names, it's quite clear that the government isn't backing down either. That is an attempt. I think I read an article with a legal scholar arguing it's an attempt to delegitimize the Supreme Court. There is also a counter view. On this panel, almost everybody seems to believe the Collegium hasn't worked. It needs an overhaul. It needs a new way of being assembled. But is there not a danger of throwing out the baby with the bathwater, to borrow the proverbial cliche?
So I see where that is coming from, that what really is the alternative that is being proposed to the Collegium, while of course we all acknowledge that it has its problems. What really is the alternative that is being proposed? I would be really curious to see how how polity reacts this time. When NJAC came, all the parties were in support of it. It was passed nearly unanimously, except for, I think, Mr. Ram Jethmalani, who was the lone abstention after having made a very aggressive opposition to the bill when it was in Parliament. But now has polity understood the implications of this, and will they be unanimously behind such a bill moved by the government? I don't think so. So perhaps in that, if there is going to be some sort of discussion, not at these conferences, not in press conferences, but in Parliament, if there's going to be an actual debate, and we can't be too hopeful about that because Parliament has not been very keen on too many debates these days. If there is going to be a strong debate, perhaps we can come up with a
better model
that addresses many of these issues.
I think that's a fair comment, that you need less opacity, more openness. Politics has changed since the NJAC was in fact unanimously or near unanimously cleared in Parliament. That's a great point, Vikram. And you need a robust debate around a new way, perhaps, of appointing and transferring judges without political vetoes actually having the last word on how judges are appointed or transferred. Thank you very much to Asim, Pandya, to Raviteja, to Alok and Vikram. Thank you so much. And to our audience, see you tomorrow, same time. Thanks for watching. It's great to see you here. Thank you for watching our work. If you haven't subscribed,